All right, welcome everybody to the December edition of the Benefits Lunch Break webinar series. Backed by popular demand, we have our Ask a Benefits Lawyer. So joining me today, this is Trip Vanderwall. I should probably introduce myself. I have my colleagues Jeff Gray, Frank Barradin, and Brett Leafbrower. Joining us from our labor and employment section, she's a rookie this year, Sandy Andre, graciously agreed to attend and address some of the employment-related questions that we got in advance. And we also have a new attorney in our section that just started in September. Nate Caverly is joining us as well today. He's going to kind of observe, but prepare next year for him to be answering all of the questions. So with that, we'll go to the next slide. This is, of course, the last Employee Benefits Lunch Break Series webinar of 2023. We are going to continue it in 2024 with slight modifications. As you can see, those are our scheduled dates for 2024. We are going to do, it looks like every other month. Yeah, that's every other month up there. Took me a minute there. So only 6. And of course, if we feel that there is something that's emerging or urgent that we need to get out there, we may supplement that. But we decided to back off a little bit just to not flood you with, webinar for webinar's sake. We have a number of questions that we got in advance, and we will address those. And then as time permits, feel free to submit questions in the Q&A, and we will try to address those as well. First one, trial by fire here, Sandy. We're going to go right to you. The Earned Sick Time Act or Paid Time Off crystal ball. Do you have any guesses and if Michigan will decide anything soon?
So the short answer is my guess is they will not decide anything soon. Just for a little bit of context here, this is related to Michigan's Earned Sick Time Act, what we now know as Michigan Paid Medical Leave, that went into effect in 2019 under an adopt and amend strategy in 2018. So what feels like my entire legal career, I have been talking about the adopt and amend strategy used to implement Michigan paid medical leave. And that has been going through the litigation process in the court system since it was enacted. And so we've been living with Michigan paid medical leave for some time. But just 2 weeks ago on December 7th, the question of whether the adopt and amend strategy violated the Michigan Constitution finally made its way before the Michigan Supreme Court, and they heard oral argument on that. And of course, depending on how the court decides, 2 laws here in Michigan might be impacted: Michigan's paid medical leave and what is the current Michigan minimum wage. So all of that to say, I don't know when they will make a decision. What I do know is the last time anything related to this litigation came before the Michigan Supreme Court, they heard oral argument in July and didn't issue an opinion until December. So I think we've got a little bit of time before we hear their decision. And I also don't have any great guesses on what that decision will be.
Thank you, Sandy. Let me guess. If you had a crystal ball, would you still be doing this as your day job?
Yes. Yeah, well, I mean, only if we get to talk about Michigan paid medical leave for 5 more years.
All right. Next question we are going to throw over Brett's way. And it says, can you review the determining factors between a welfare benefit plan and a payroll practice with respect to short-term disability plan? So this, I think, Brett, is what they're getting at is, when is an STD benefit subject to ERISA versus when does it qualify as this exception for a payroll practice and not subject to ERISA?
Sure. So a short-term disability plan or STD plan will or will not be subject to ERISA depending on whether or not it's considered to be a payroll practice. So specifically, if the STD plan is considered to be a payroll practice, it will not be subject to ERISA. And the primary factor that goes into determining whether or not it's a payroll practice is how the STD plan is funded. So if it's fully funded by the employer, that meaning there are no employee contributions, that plan will likely be considered a payroll practice.
Right, well, let me clarify though. What if you have a fully insured short-term disability benefit that's fully paid for by the employer? Is that?
So a fully insured STD plan will still be subject to ERISA.
So all fully insured, whether it's contributory by the employee or all paid for entirely by the employer, will always be subject to ERISA.
Yes, that's
So
right.
we do need a self-funded plan in order for the payroll practice exemption to apply.
Yes, that's right. Thank you for that clarification. A couple other factors that are relevant is the STD plan must be in place for either full or partial compensation replacement for the employee. So if for some reason you had an STD plan that was paying someone more than their full compensation, you would then have an ERISA plan in place. And one other factor is that the STD plan must be in place and the person must be on that disability for medical reasons.
Couple other things. If you're once you terminate employment, can you still be eligible for STD benefits even if you're currently receiving STD benefits, or do they need to stop?
No, those STD benefits need to stop if you're no longer employed.
Exactly, because we don't. If it's a payroll practice, we don't pay former employees generally, right?
Right.
And of course, if you are documenting the short-term disability plan, which we always recommend, we want to make sure that we avoid any references to ERISA or participant rights in that documentation, correct?
That's correct.
All right, Brett, we're going to stay with you on this next one. Can an employer contribute, actually, this is submitted twice, I got cut off here. Bear with me. Can an employer contribute $250 to a medical flexible spending account for a retiree that they offer medical benefits to post-employment, as long as the employer does not allow the retiree to contribute any of their own money to the FSA? The employer in this situation is trying to help compensate for an increase to the deductible. This is a non-ERISA group under 50.
So the short answer to this question is yes. The employer can contribute $250 to an FSA under these circumstances. And I say under these circumstances because there are two key points in this question that allow this arrangement to be permissible. And the first is that this employer happens to be offering the retiree medical benefits. So in order to participate in a medical FSA, the participant must be offered a group health plan by the employer. The retiree meets that requirement here. And the second requirement that's met here is the employer is only offering $250 to the medical FSA. So there is a maximum benefit condition for FSAs. And the maximum that an employer can contribute if the employee is not contributing anything is up to $500. So we have that requirement met here. And then one other point I'll mention is that a retiree cannot contribute any funds to the medical FSA. And that is because the retiree does not have any salary for purposes of a pre-tax salary deduction. And in the fact pattern here, the retiree is not contributing to the medical FSA.
And the reason that we want to satisfy the availability condition, which is offering the individual and other health plans, and the maximum benefit condition is for what reason, Brett?
That is for purposes of the medical FSA to be considered an accepted benefit.
Because if it's not an accepted benefit, it is of course subject to
the Affordable Care Act and integration with health plans.
Medical FSA is kind of by definition, since they impose annual limits, can't satisfy the ACA. So it's imperative that FSAs be an accepted benefit. We did get a question that came in live with respect to your STD question. It says, is a self-funded but a gross up on premium is passed to the employees, that's still considered to be free of ERISA? I'll field that. So again, we have to have a self-funded plan. In the way that STD benefits are taxed, if they're paid for by the employee, if the premium is, if the illustrative rate, again, because it's self-funded, we don't really have a premium, is paid for by the employer or paid for on a pre-tax basis by the employee, the STD benefit is going to be taxable when those disability benefits are paid to the employee. So in this situation, I think what the individual is saying is, hey, we have a self-funded plan, but if we gross up the value of the employer contribution, is it still going to be considered to be free of ERISA? And the reason that we would gross it up is so that the STD benefits would be tax-free when paid. I don't think that you would lose your payroll practice, but I think you would have to figure out how you were, because again, you can't have a fully insured plan be exempt from ERISA, so it has to be self-funded. So we'd have to come up with some way to come up with an illustrative premium-ish rate that we're going to gross up. Again, without the premium, that may be difficult, but I don't think the fact that you have a gross up is necessarily going to jeopardize your ERISA exemption. All right, Frank, next one's coming to you on the retirement side. We kind of have two that are close. So I'll read the one that's a little bit, more in depth, and we'll treat that as covering both. So what does it look like for employers to treat matching and non-elected contributions as designated Roth contributions? Can this only apply to 100% vesting immediately, or once they hit the 100% vesting after a 5-year schedule? How are the employer contributions taxed?
Well, this is a pretty easy one to answer, and it's one that is consistent with a lot of the things I've been saying over the last year or so about the Secure 2.0 Act that added this provision. It's, in my opinion, it's something that was added as kind of garbage. I'm not exactly sure who the one was that was promoting this or what group, but I see no purpose for any plan to be doing this. And partly it's because, so the easy answer is that these contributions to be taxed just like somebody making their own Roth 401k contributions, except that there would be no payroll taxes, just like regular 401k, pre-tax 401k. But unlike that, I should say, the employer contributions are not subject to payroll taxes, whereas the employee deferrals are. So if you had an employer contribution made on a Roth basis, it would be subject to income taxes, but not payroll taxes. But the bottom line is, why would any employer want to do this? First of all, the issue about vesting, yes, it wouldn't make any sense for an employee to pay tax on money that they may never get, so if they weren't vested. So yes, you could do it for plans that are immediately vested contributions. But once again, once they added the in-plan Roth conversion option a few years ago, that gives employees all the flexibility they could possibly want to convert amounts from pre-tax to Roth contributions at any time. Obviously, your plan can dictate that. It doesn't have to allow that. But if it does, it can allow it, and it can allow it at any time. And there are many record keepers now that are offering that or able to process that. So that then, in my opinion, all employers should continue to make their employer contributions on a pre-tax basis, and then provide that flexibility for any participants who want to convert it to Roth later. It doesn't make any sense in my mind. And once again, I don't know why this was even included in the law as an option, because I don't see employers adopting it to actually make their contributions on a Roth basis.
It's interesting, Frank. I heard at a conference we were at, with the Roth conversion, that there's record keepers that for participants who are 100% vested, they can select an option that the second that the employer contribution is made, it's automatically converted to Roth. So at the end of the day, it's basically, they're already doing what this new law applies.
Yeah, and that's a classic case of the government or Congress being a step behind and not really maybe talking to the actual people in this world that deal with this on a daily basis to understand that, they just added a bunch of complexity and somebody's going to have to spend time writing regulations on something that probably won't get used at all.
All right, Sandy, we're coming back your way for a couple different questions here. So first, we'll start off with, for the 2024 exempt salary requirements, what is considered salary? Would it include any commissions paid out or earned? What about bonuses?
Okay, a little background and a little context here. First, it's super important to remember that you need to follow the wage and hour law of whatever state your employee is in. Many states have lower salary thresholds or lower requirements than federal law. So many states defer to federal law to set the standard here, but not all states. Many states have higher salary thresholds for exempt classifications and so on and so forth. So you got to take a look at what state law plays into any particular question. But a little bit of background on the salary basis. So in August of 2023, the Federal Department of Labor issued a notice of proposed rulemaking changing the salary basis for exempt classified individuals. So remember, to be considered exempt under the Federal Fair Labor Standards Act, you have to meet 3 requirements to be exempt from overtime. You have to be paid on a salary basis. You have to be paid at least a certain amount, and that's called the salary threshold. And you have to satisfy the duties of one of the duties tests related to whatever exemption you're looking to qualify for. Executive, professional, administrative are generally the most common. And so if you don't meet all 3 of those requirements, you can't be, that employee, that position cannot be classified as exempt from overtime. So for a long time, we've been waiting on the Federal Department of Labor to issue an update to the exempt rule. And we were hoping that maybe they would make a change to the duties test or provide some additional guidance there. But what came out in August was a proposal just to change the salary threshold. So the current salary basis is $684 a week. The proposed rule would take the salary basis to $1,059 a week. It's important to remember that's just a proposed rule. It's still going through the rulemaking process. It has not been finalized. So as we sit today, we work with the 684 as the salary threshold. But to get to the very specific question, can you include commissions and bonuses? So employers can use non-discretionary bonuses and incentive payments, including commissions, that are paid on an annual or more frequent basis to satisfy up to 10% of the standard salary threshold. So, and even after an entire year, if you as the employer haven't met that financial obligation, you can do one final, what we call a catch-up payment within one pay period at the end of your 52-week year to bring that employee's compensation up to the required $684 a week level. And that catch-up payment, so for example, if you were doing that in January of 24 to satisfy the requirement for calendar 23, you would count that catch-up payment, of course, only towards the 2023 salary amount. You would not be able to count it towards qualifying for the 2024 salary threshold amount.
Perfect. Thanks, Sandy. Right back to you. Let's see if I can get these acronyms right. So, has there been any clarification and eligibility regarding the Pregnant Workers Fairness Act? Did I get that right?
You got it.
All right. So then they reference our episode 50 of our very popular Off the Clock series with Sarah and Rebecca. And it says, has the EEOC expanded the definition of pregnancy to include post-pregnancy, childbirth, miscarriage, infertility? Does this include men? Abortion? Any other updates?
Okay. So the short answer is no updates. You might remember, of course, that the Pregnant Workers Fairness Act went into effect in the summer. And in August of 2023, the Department of Labor issued proposed regulations associated with the Pregnant Workers Fairness Act. And among many aspects of those proposed regulations that made our employment section attorneys, all of our eyebrows go up, was this potential expanded definition of pregnancy-related medical conditions. The proposed regulations say that they borrow the definition from Title VII, and so we think, okay, we know what that means. But they also say these proposed regulations are going to provide some additional examples of what these related medical conditions include, and it is expansive, just as whoever asked this question was right on that. Past pregnancy, potential pregnancy, lactation, use of birth control, infertility and fertility treatments, no specificity related to sex assigned at birth or gender, endometriosis, miscarriage, so on and so forth. So you're right that the proposed regulations certainly expand on what we've traditionally thought pregnancy and pregnancy-related medical conditions have meant. But we don't have any final word on that just yet, still in the rulemaking process. The comment period did close at the end of October. So we just sit and wait, kind of like the salary threshold.
Well, and it's interesting. In your world, we may see a big push for proposed regulations to be finalized in 2024. Because if we have a change in presidential administrations, the first thing a new president does is freezes and retracts any regulations that are kind of in the pipeline from the previous administration. So a lot of times they try to push these out before there's a change in administration. So I wouldn't be surprised, well, in our world, if not your world, that we see a flurry of regulatory activity in 2024.
Well, that's kind of a bummer. I was planning, to take a 7-month sabbatical or something, but I guess you're saying that
That's not going to happen. No,
Okay.
no. All right, one last question for you, at least right now. It says, I know we can't withhold last pay for not returning company items, but can we turn off direct deposit and turn it into a paper check and request the term person to come in the office to pick it up? Hopefully not to break their knees or anything. How long can the check sit there before we must mail?
Okay, so I'll give my state-specific disclaimer on answering this question too. Remember, where your employee is performing work for you, that state law is going to dictate requirements in this area. So we'll just assume we're talking about a Michigan employee. So we've got a couple of Michigan statutes that we deal with here. The Payment of Wages and Fringe Benefits Act, which tells us that employers must establish regular pay periods. They must be at a certain clip, and final wages must be paid as soon as reasonably calculated, but can be on the employer's regularly scheduled pay day. So that's kind of the first underlying piece, is that we do have to issue payment on that last day. We do not have to pay. There's no requirement that we pay by direct deposit. And what I would recommend here is that if you're making that rule that final pay switches to a paper check, we don't just pick and choose who we apply that to, right? That just opens the door for maybe we're doing that only to men or to women or to a certain race or religion, so on and so forth. So if that's your standard policy, you can go ahead and make that change. But one thing you need to be aware of is you can't just sit, that check just can't sit in the payroll office's drawer for forever and ever. If an employee doesn't come claim that within a reasonable time period, you need to be taking reasonable steps, diligent steps to contact that individual to come and get this check. And then under Michigan's Uniform Unclaimed Property Act, if you still have that payroll check and it's more than $50 and it's been unclaimed for a year, it's presumed abandoned property and you have to do some reporting to the state of Michigan. So all of that to say, can you change from direct deposit to paper here in Michigan? That's fine if that's what you want to do, but you have some obligations to engage in due diligence to get that payment to the employee who earned the wages.
Perfect. Thanks, Andy. We'll give you a break for a few minutes.
Thank you.
Jeff, wake up. Okay, this is kind of a specific question, so bear with us here. So in a church retirement plan, does designating pay as a minister's housing allowance under section 107 of the Internal Revenue Code preclude it from being categorized as includable compensation under section 415C of the code, but while not impairing its inclusion under 401A17 for defined benefit plan accrual purposes? That was a mouthful.
Yeah, thanks, Trip. That's a tricky one. That one is a pretty narrow question, but I have a couple of thoughts. So housing allowance is something that a church can provide to a minister. That's it's a non-taxable amount for housing. It's kind of based on the historical practice of providing parsonage to a pastor. And so when you're dealing with, when you're looking at the 415 limits, like the 415C limit in a 403B plan, you're trying to figure out, okay, what counts towards that limit when you're looking at the lesser of 100% of someone's compensation or whatever that limit is in a year. It's $66,000 this year. And so I think the question is, does that housing allowance count when we're looking at that limit? And the IRS back in 2001 issued a private letter ruling saying, no, it doesn't count towards that 415. Not 415 compensation. It doesn't count towards that 415C limit. And that's a private letter ruling is 2001 35045. So 2001 35045, if you want to look that one up. Second question, I think, is just whether, since we're not counting it for that purpose, does that mean we can't count it for purposes of like a defined benefit plan accrual? And the answer there is that it can be counted. From what I can tell, there's a revenue ruling from 1973, so it's 73-258, where the IRS looked at that housing allowance and said, yes, you can base a benefit plan accrual on that. I mean, that predates ERISA and predates 401A17 necessarily, that limit, but it would be subject to that limit. And the point is, yes, you could base an accrual on that type of compensation if you want. Having said that, all this depends on how the plan's written, and it's a pretty particular question that you might want to look into a little more closely, but it'd be good to start with those two pieces of IRS guidance.
Perfect. Thanks, Jeff. And it looks like we didn't lose too many participants during that. I'm just kidding. I joke. All right. Next one is for me. What are the regulatory requirements under the CAA for reporting for self-funded employers? And this is kind of a loaded question because the CAA has all kinds of impacts on employer-sponsored group health plans. In fact, I think it's probably the most significant piece of legislation impacting employer-provided group health plans since the Affordable Care Act. And it was kind of passed in the middle of the night. It was signed on December 27th of 2020. And some of the provisions took effect immediately. Some were lagged out. Some have been further delayed. But I would say there is three main reporting requirements where you're actually reporting information to the federal government. The first is what we call the RxDC, which is the prescription drug reporting requirement. We've already been through a couple rounds of this. It was first due, I think, in January 31 of this year, and then it was due June 1 and will continue to be due every June 1. Now, fortunately, even though the obligation to complete this reporting falls on the group health plan or the plan sponsor that sponsors the self-funded health plan, the reality is you just don't have the information to do the reporting. That is going to be held by your plan's TPA or administrative services contract only administrator. And we found that most of those TPAs are doing the reporting on behalf of their self-funded clients. Now, keep in mind that if they mess up, they fail to report or they report something that's inaccurate, and the Department of Labor, IRS, or HHS imposes some type of penalty, that penalty will be applied on the plan, not the TPA. Even if the TPA agrees by written agreement to do that reporting, it's not going to transfer liabilities for any mistakes or failures to report. So really the only way to protect you there is through some type of indemnification with the TPA. We have, just like we found that most TPAs are willing to do that, we have found that TPAs are not so willing to provide any indemnification. They'll do it on your behalf, but you're on the hook if there's any problem with it. The second reporting requirement is this gag clause attestation. The first one we're doing is due December 31 of this year. And that gag clause attestation applies for the period of December 27, 2020, which was the date the Consolidated Appropriations Act was signed, in December 31 of 2023. So kind of a 3-year period. After that, it's going to be due every December 31. It's only going to apply for the immediate calendar year. So when it's due December 31 of 2024, the reporting or attestation period is only the 2024 calendar year. And really what this is you're attesting to the government that none of your contracts or agreements entered into by or on behalf of your plan have any of these gag clauses which prevent certain information from being disclosed to certain parties. Again, for self-funded clients, the obligation to do this gag clause reporting is on the plan or plan sponsor. But the TPA may be willing to do it and is permitted to do it on your behalf. Now, unlike the RxDC or prescription drug reporting, we've seen a little bit more variance in which TPAs are willing to do this for you. Just because we're sitting here in Michigan, I will tell you that Blue Cross Blue Shield of Michigan agreed to do this on behalf of their self-funded clients, but you had to notify them at some point in November, and I can't remember the exact date that you wanted them to do it. If you didn't provide that notification, it's still on you to prepare. Priority Health, they are making their self-funded clients do the reporting on their own. They are providing you with a letter that says none of the contracts that they've entered into on behalf of your plan have any of these prohibited gag clauses. Express Scripts, they are making you report on your own. They are not willing to do it. So again, I think if you're not aware of this, you should reach out to your TPA, discuss who's going to do it. Have they done it already? And if not, it is due December 31. Of course, so we've got a couple of days, and the actual process is not that hard. I just helped a client do it yesterday. But December 31 is going to sneak up on us, especially with the holidays. The third and final reporting requirement is the air ambulance reporting requirement. I'm not going to touch on that. That's due March 31 each year, but it has been delayed until we get regulations, which we haven't gotten yet. Again, I think this is going to be a reporting requirement your TPA is going to have to do on your behalf. I think it only is a reporting requirement for 2 or 3 years, so it's going to go away. But again, a lot of the information plan sponsors aren't going to have. With that, we're going to move back to Brett. Brett, it says the next question is when it comes to the marketplace or individual plans, can we still offer cash in lieu to employees, cash in lieu of benefits, or opt-out payments, some call to employees, and follow ACA guidelines or requirements?
So an employer is permitted but not required to provide its employees with additional compensation or cash in lieu payments if the employee waives medical prescription drug coverage under that employer's group health plan. Now, under the Affordable Care Act, there are some issues associated with providing these cash in lieu payments. And first of all, if these opt-out arrangements were in place before December 16th, 2015.
Which was the date that the IRS rule guidance on this came out. They don't necessarily pick the most odd dates, but that's often how it turns out to be. Anyway, keep going, Brett.
Right. So if the opt-out arrangement was already in place prior to that date, there are no additional considerations under the ACA specifically related to the affordability requirement. Now, if an employer is newly providing opt-out payments after that December 16th, 2015 date, and certain requirements aren't met to make these eligible opt-out payments, the value of those opt-out payments need to be treated as employee contributions for purposes of affordability under the Affordable Care Act.
So really what you're saying there is if you have a cash in lieu that you would put into place after December 16, 2015, you have to include the amount of cash in lieu for purposes of affordability in determining if you've offered affordable coverage under this quote unquote pay or play penalty, correct?
That's right. So the general rule, if the employer doesn't have eligible opt-out payments, is that the amount of these payments will count against the employer and employee for purposes of affordability under the affordable.
Now, I will point out that this guidance that came out back in 2015 talked about this requirement, of including cash in lieu and for purposes of affordability, unless you have this eligible opt-out arrangement. But they also they're going to issue proposed rules or additional guidance on this, which the IRS has never done. So I do have some, there's at least defensible argument that this rule doesn't apply. And if you have a cash in lieu that you created after December 15th of 2016, you still don't need to include it for affordability purposes. But that's, I think, a little bit more based on the risk tolerance of each employer. With that, I'll take the next two. So where do wellness discounts stand for company incentives? Would love to see any discounts again tied to medical premiums. So wellness plans are subject to a host of rules, specifically the Affordable Care Act and HIPAA. We have very, very clear, concrete rules that apply to wellness programs under the ACA and HIPAA. But if you have a wellness program that includes a medical exam, such as a biometric test, or a disability-related inquiry, such as a health risk assessment, now we are potentially in ADA GINA territory, and this is where the requirements are very, very unclear. We had some regulations that were passed back in 2018; those were rescinded in 2020. So the question is how much, if we are subject, our wellness program is subject to the ADA, how big of an incentive or penalty can we have for not satisfying the wellness criteria? That is still unclear. I still think you can have wellness incentives tied to the premium. And my general recommendation is that we abide by the old ADA regulations that say you can't surpass 30% of the total cost of coverage under the cheapest cost plan. Just keep in mind that that's no longer a safe harbor. There was a quick other question in this. It says, ACA, any talk about stopping the yearly company filing? I think by this question, they're referring to this annoying 1095C reporting requirement for applicable large employers. No discussion on that ending. I don't think the IRS has the ability to end that. It would require some act of Congress. And keep in mind, though, that if you have any employers out there on the line that file these in paper format versus electronic format, that's probably not going to be an option anymore for you for 2023. And that's because when you look at, there's an exception is if you file less than 250 of these forms, you can file them in paper. Now that exception dropped to 10, and you have to aggregate all kinds of forms. So when you're looking at whether you exceeded 10, it's not just 1095Cs, it's W-2s, it's 1099 miscellaneouses. And so if you think that you have to have at least 50 full-time equivalent employees to be an ALE, you're definitely going to have more than 10 of just these forms that you have to file. So electronic will be required. Next question is, employers look to on-site or concierge type health benefit solutions. Compliance concerns have come up around offering these types of services to HSA participants, as it could threaten their eligibility into the HSA. And that's absolutely right. Remember, to be HSA eligible, you got to satisfy two requirements. First, that everybody seems to be aware of, is that you're enrolled in a qualified high-deductible health plan. The second is, with limited exceptions, you can't be covered by any health plan that's not a qualified high-deductible health plan. So here the issue is covering people under a concierge or on-site medical clinic, arguably is a health plan that's not a high-deductible health plan, and therefore, if I have access to this and I'm an HSA participant, I no longer will be HSA eligible. There hasn't been any movement on this. We need some act by Congress. So right now, kind of the typical solutions are either to charge your HSA participants the fair market value of coverage for access to these on-site or concierge clinics, at least until they satisfy the minimum deductible. And keep in mind that particularly with on-site wellness vendors, a lot of times they'll say it's just $40 per visit. I'm not sure that that's accurate. If they're providing a wide range of services, I think it's a hard argument to make that everything that they provide, the fair market value, is only like $40 a service. So it's probably better than nothing, but it's not a home run. We may see some movement on this, particularly, we've got some legislation that said, hey, HSA participants can have access to telehealth services without jeopardizing their HSA eligibility. It's temporary relief that only extends through the 2024 plan year. But I wouldn't be surprised to see that amended. And maybe if we're lucky, Congress, when they extend that exception for telehealth, may include on-site concierge type medicine, as these are becoming more popular arrangements. With that, Sandy, back to you. With regard to the Pregnant Workers Fairness Act, if an employee is asking for, given a reduced schedule, and they temporarily drop below 30 hours required to be eligible for our medical insurance, may we drop them off the plan, or must the employer carry them because it's a temporary change?
So if you're providing a reasonable accommodation like leave or intermittent absent, right? Continuous leave or intermittent leave as a reasonable accommodation under Pregnant Workers Fairness Act, what you need to do is you need to treat that reason for leave as you would any other type of leave, right? If you have an employee who is off for a different medical reason, if you have somebody who is, I don't know, off on layoff related to, I don't know, sabbatical or something like that. What you don't want to do is specifically treat the leave associated with pregnancy or pregnancy-related medical condition different than you would treat any other type of medical reason or need for leave.
But unlike the FMLA, there's no necessary requirement to continue health insurance to people under the Pregnancy Workers Fairness Act, to people that aren't otherwise meeting their eligibility.
Of course, yes, that's exactly right. So, right, that's the difference. We've traditionally kind of thought about FMLA and ADA, and Pregnant Workers Fairness Act is ADA-like, right? That there's no requirement to maintain benefits there. There's not even necessarily reinstatement rights, all of those pieces. But you can't treat leaves for medical reasons different than you would treat them for other types of reasons. So as long as you are doing that consistently, right? Again, if we're talking about things that are totally outside of FMLA, as long as you're administering that consistently, at least what we know about Pregnant Workers Fairness Act so far, you'll be fine.
Perfect. Thank you, Sandy. Yep. Brett, over to you. Regarding ACA stability periods, if a full-time employee moves to PRN as needed status, which is not eligible for benefits during the ACA stability period, we are prevented from terminating, terming their benefit coverage. It must keep them at full-time status through the stability period. However, and let me, before I go on, remember, this is for employers that are applicable large employers. If you use the measurements, look back measurement period to determine an employee's full-time status, they're basically an employee is treated as full-time for an entire stability period as long as they're still employed based on their hours in the measurement period. So if they drop to a PRN status or as needed and drop way below, they're still at least considered full-time, and you need to continue to offer them affordable minimum value medical prescription drug benefits in order to avoid one of these pay or play penalties. With that background, says, however, an employee may elect to drop benefits when changing status to PRN from full-time. Is this correct? And are we required to ask for any documentation from the employee regarding other benefit coverage if they request to drop coverage through us?
So in this case, it appears that the employer's plan is drafted such that the reduction in hours has not caused the employee to lose eligibility under the group, the employer's group health plan. So the question is whether the employee can drop coverage. And this is governed by the rules under Section 125 of the Internal Revenue Code, also known as the cafeteria plan rules. And prior to 2014, an employee could not drop coverage based on a reduction in hours under these circumstances. But in 2014, the IRS released some guidance, which basically allows the individual to revoke coverage as long as the revocation and the language used in the IRS notice, as long as the revocation corresponds to the intended enrollment of the employee, and if applicable, the employee's dependents, such as his spouse and children, in minimum essential coverage. And the second part of this question is, what sort of documentation does an employer need to obtain regarding whether an individual intends to enroll in minimum essential coverage? And in that IRS notice, it states that cafeteria plans and employers may rely on the reasonable representation of the employee, either that employee is already enrolled in alternative minimum essential coverage, or that employee intends to enroll. So one way that an employer might be able to satisfy that requirement is to have its employees sign an attestation form that they want to drop coverage because they intend to enroll in minimum essential coverage.
All right, thanks, Brett. We're getting close to our previously submitted questions. The next two I'll address. So the first one is, an employer is a small group age banded rate. So that means they're in the adjusted community rating rules under the Affordable Care Act. Can they charge their employees different premium contributions based on the age band rate? An example, employer charges 25% of the employee, or of the premium, excuse me. Employee one is 24 years old, and her premium is $209.32 from the carrier. Employee two is 61 years old, and his premium is $780. Can the employer have each employee contribute 25% of their age-banded premium to the cost of their insurance? So the employee the younger employee, would be contributing $52.33 a month, or the employee two, the older employee, would be contributing $195. Yes, this is permissible. You can either, contribute the same flat dollar amount or the same percentage amount. And the fact that the age-banded rates and a percentage may make the older employees pay more, that is permissible. It's not a violation of the Age Discrimination in Employment Act. Last of the previously submitted questions, we have been discussing bringing on the child care benefit called TRICARE, not one that I'm familiar with. Our issue is that the benefit would be limited to a small number of employees. What's the best way to offer this benefit, but have an equitable offering for all employees? I thought of a lifestyle account that we can offer to employees. They could have their choice between that and TRICARE. Your thoughts on this would be greatly appreciated. Without saying more, I mean, certain child care benefits can be provided on a tax-free basis under Section 129, but if you already have a dependent care FSA, we've got to kind of keep track of what those limitations are. So it's maybe possible. A lifestyle account is one of these new arrangements that's becoming increasingly popular, particularly in light of the overturning of the Roe versus Wade decision. I think you could do this. And basically what a lifestyle account is it's a post-tax or after-tax reimbursement where individuals are eligible for certain reimbursement for certain expenses related to their lifestyle. Gym equipment, gym memberships, and here childcare, that type of stuff. So I think that is potential. When you're setting these up, you want to set them up appropriately and intentionally. So for example, if you are going to cover mostly medical care under this, it's probably going to be a group health plan. You're going to be subject to COBRA, ERISA, blah, blah, blah. So if we want to make it, if you don't want to be subject to that host of alphabet rules, we probably have to set this up to cover a broad range of expenses. But of course, we want to have some guardrails, right? We don't want to be reimbursing our employees for their weekend beer and cigarette expenses, I'm guessing. So a lifestyle account may work, but it's probably something you should talk to with your own counsel. Moving over to the submitted questions. And again, we've got a couple more minutes. We will end at 1 at the latest. We have 2 questions. Can an employer include in their SPD that employees over 65 years old can leave group coverage for Medicare, but keep their non-employee spouse on group coverage, or is that the carrier's discretion? So keep in mind, as long as you have at least 20 employees, you have to be really careful with the Medicare secondary payer rules. We can't provide any incentive at all for our Medicare eligible employees, spouses, to leave our plan and go enroll in Medicare. Now we can educate them, and that's where I think you got to be careful where you're not crossing the line. It says, hey, Medicare may be better for you, but we can't pay them. We can't reimburse their Medicare premium. We can't give them a better parking spot if they drop coverage and enroll in our plan. Now, if you have someone that in this situation, this is kind of a 2-part question. The employee drops coverage under the employer's plan to go to Medicare. Can the employee stay? Can the employee spouse stay on? I suppose you could, again, if you're fully insured, that could be up to your carrier. You have to work with them. If you're self-funded, you may have a little bit more flexibility, but I have never come across a plan that has allowed an employee's dependents to be enrolled on the plan when the employee wasn't also. So what would most likely happen, employee drops coverage due to Medicare, spouse stays on for 36 months under COBRA, and then has to find some other coverage, whether they become eligible for Medicare or go to the individual exchange or enroll in coverage through their own employer. I've never seen an employee's spouse or dependent children be allowed to enroll in an employer's coverage if the employee waives that coverage. Employee and spouse both have health insurance through their respective employers who are different employers. Employee A enrolls in a high deductible health plan with HSA and includes tax-dependent children, family coverage under the high deductible health plan. Spouse, employee B, enrolls in traditional plan as single coverage. Can employee B in a traditional plan, in a traditional healthcare plan, can employee B, enroll in a traditional healthcare flexible spending account without disqualifying employee A's HSA eligibility? And the answer is yes, as long as the spouse's employee B, that their employer's medical FSA or healthcare FSA excludes the other spouse, employee A, from having his or her out-of-pocket expenses be eligible for reimbursement under the medical FSA, or only that spouse's limited expenses, so dental, vision, preventive care. Because again, when we're looking at HSA eligibility, we're looking at eligibility of the account holder. Here it's employee A. And we have those two requirements, right? Is employee A enrolled in the qualified health plan? Check, you've met that. Second requirement, do they have any other coverage under non-qualified health plan? Well, if employee B's employer's medical FSA is a general purpose and covers employee A, boom, we failed that second requirement. Employee A is no longer HSA eligible. If employee B's employer's FSA either excludes employee A or limits employee A's to limited purpose FSA, the employee has met that second requirement and remains HSA eligible. With that, we'll give it a couple seconds to see if we have any other questions that come in. Oh, we have one here. Is it up to the carrier to decide whether they want to allow foster children to be covered under plans, or do they need to be a legal dependent in order for them to be covered? So the ACA requires certain dependent coverage to be offered under the Affordable Care Act, but that requirement does not apply to foster children. Now, most employers will extend coverage to employees' foster children, but that is a plan design decision. Again, if you're fully insured, one, to check with your carrier. If you're self-funded, you have more flexibility, but you want to make sure that's properly included in your plan for stop-loss purposes. All right. It looks like that's all of our questions. Thank you guys for joining us today. Have a great rest of the 2023 calendar year. Happy holidays, and we look forward to seeing you in 2024.